In just 31 seconds, Federal Judge William Alsup confidently dismissed Congresswoman Jasmine Crockett's legal argument with a condescending wave of his hand. But what happened next left the entire San Francisco courtroom in stunned silence. The response she delivered, calmly citing the judge's own forgotten ruling from 2011, would transform not just the hearing, but how judicial accountability would be understood. For years to come, the Philip Burton Federal Building courtroom gleamed with polished oak and brass that morning. Sunlight streamed through tall windows, illuminating the Great Seal of the United States, mounted prominently behind the bench. The atmosphere carried the weight of institutional authority, a place where legal arguments lived or died based on a judge's assessment of their merit. This wasn't merely another federal proceeding. This was the culmination of a landmark voting rights case with implications for millions of disenfranchised Americans. Legal observers had filled every seat, journalists lined the back wall, and civil rights veterans who had fought for decades watched with expressions of measured hope. Judge William Alsup, appointed to the federal bench in 1999 and renowned for his sharp intellect and even sharper tongue, presided with the confidence of a jurist who had heard thousands of arguments in his distinguished career. At 78, his reputation for technical precision and occasional impatience with unprepared attorneys had made his courtroom a proving ground for legal advocates. Jasmine Crockett sat at the counsel table, representing the plaintiffs in her capacity as both a congresswoman and constitutional attorney. Her posture conveyed focused determination rather than intimidation. Her legal materials were arranged with methodical precision, color-coded tabs extending from critical precedents, each page annotated with her precise handwriting. "Congresswoman Crockett," Judge Alsup began, glancing over his reading glasses, "your argument relies on an interpretation of Section ER-2 that has been repeatedly rejected by the Supreme Court. I fail to see how you expect to prevail where so many before you have failed." The dismissive tone wasn't unusual for Alsup, whose direct questioning had unsettled even the most experienced advocates. The slight smirk that followed his statement reflected the confidence of a judge who believed he had identified a fatal weakness in the case before him. What neither Judge Alsup nor anyone in that courtroom realized was that for 17 weeks, Congresswoman Crockett had been methodically studying not just voting rights precedents, but Judge Alsup's complete judicial record, over 2,000 opinions spanning 2 decades on the federal bench. And within that massive archive, she had discovered something that would transform the trajectory of this critical case in less than 5 minutes. If you believe in the power of thorough preparation to overcome even the most entrenched authority, make sure to like this video and subscribe. What you're about to witness isn't just a courtroom exchange, it's a masterclass in how meticulous research can rebalance the scales of justice when they seem permanently tilted against change. Before stepping into Judge Alsup's courtroom that morning, Jasmine Crockett had built her reputation on a foundation of meticulous preparation and principled advocacy. A graduate of the University of Houston Law Center who had distinguished herself as a civil rights attorney before entering Congress, she approached constitutional litigation not just with passion but with surgical precision. "Your Honor," Crockett began, her voice measured and respectful, despite the judge's dismissive tone. "I appreciate the court's concern about the Supreme Court's recent Section 2 jurisprudence. However, our argument today is grounded in a more nuanced reading of the statute that addresses those very limitations." Judge Alsup leaned back slightly, his expression skeptical but attentive. Having spent over 2 decades on the federal bench, he had developed a reputation as a judge who, while occasionally brusque, genuinely engaged with substantive legal arguments regardless of their source. "The Supreme Court has been quite clear." "Counselor," he responded, gesturing toward the defense table where state attorneys sat with confident expressions. "The totality of circumstances test you're proposing has been significantly narrowed. Your interpretation seems to ignore that evolution." The gallery responded with the subtle rustle of notebooks and muted typing from reporters. Legal observers exchanged knowing glances. This appeared to be following the pattern of numerous voting rights cases that had faced increasingly restrictive interpretations in recent years. What they couldn't see was the calm calculation behind Crockett's composed expression. While preparing for this hearing, she had made an extraordinary discovery, a 2011 opinion written by Judge Alsup himself in a little-noticed case involving Native American voting rights in Northern California. In that opinion, Alsup had articulated a theory of Section 2 interpretation that directly supported the position he was now dismissing, a position he himself had championed before the Supreme Court's recent rightward shift, Your Honor. I believe there's a framework for Section 2 analysis that addresses the Supreme Court's concerns while still fulfilling the statute's essential purpose, Crockett continued, her fingers resting lightly on a document separated from her other materials. Judge Alsup's eyebrows raised slightly. And what framework would that be, Congresswoman? Something the Supreme Court has somehow overlooked in its extensive voting rights jurisprudence. The subtle condescension in his tone was unmistakable. The slight edge of a judge who believed he was dealing with an advocate advancing a politically desirable but legally unsupportable position. Not at all. Your Honor, Crockett replied evenly. The framework I'm proposing was actually articulated with remarkable clarity by this very court. Something in her tone, not confrontational, but precisely confident, caused several legal observers to sit forward slightly. Judge Alsup's expression remained skeptical, but those who had appeared before him many times noticed a subtle shift in his attention. This court has handled numerous voting rights cases, Counselor. You'll need to be more specific. Certainly, Your Honor, Crockett responded. I'm referring specifically to Little Bear v. Mendocino County Board of Supervisors, decided by Your Honor in March 2011. The shift in the courtroom atmosphere was subtle, but unmistakable. Judge Alsup's expression changed almost imperceptibly, a slight narrowing of the eyes, a momentary stillness that hadn't been there before. Little Bear was not a widely cited case, having been decided during a period when voting rights jurisprudence received less national attention. What made this moment extraordinary wasn't just Crockett's knowledge of an obscure case, but the strategic significance of its author. She wasn't citing a distant Supreme Court precedent or an opinion from another jurisdiction. She was citing Alsup's own words, his own legal reasoning, his own judicial philosophy expressed when he believed no national spotlight was shining on his courtroom. Little Bear addressed a distinct factual scenario, Alsup noted, his tone now more measured, the earlier dismissiveness replaced by more careful engagement. Those who knew him recognized this shift. The judge was now fully intellectually present, his formidable legal mind actively processing the argument being presented. The factual scenario was indeed different, Your Honor, Crockett acknowledged. But the interpretive framework Your Honor developed addresses precisely the tension we're discussing today. As she opened a leather portfolio containing her key evidence, legal observers in the gallery recognized they were witnessing something rare in federal litigation. A moment when the typical power dynamics of a courtroom had been subtly but significantly rebalanced through sheer force of preparation. Crockett didn't just know the law, she knew this specific judge's own articulation of it, an articulation he himself might not have recalled from among the thousands of opinions he had authored. It was preparation so thorough it transformed the advocate from supplicant to intellectual peer, creating a foundation for legal discourse that transcended the usual hierarchical exchange. In Little Bear, she continued, Your Honor wrote that when addressing Section 2 claims, courts must balance fidelity to textual analysis with recognition of the statute's remedial purpose, formalistic interpretations that preserve the appearance while defeating the substance of voting rights protections cannot be what Congress intended. The quotation hung in the air. Alsup's own words, precisely researched and directly applicable to the case before him. The judge's earlier smirk had vanished entirely, replaced by the focused expression of a jurist confronting his own prior reasoning. That language addressed a specific aspect of the Mendocino County voting system, he noted, though his tone had lost its dismissive edge. Indeed, Your Honor, Crockett agreed. And it's that precise interpretive approach, focusing on substance over formalism in voting rights analysis, that forms the foundation of our argument today. As she prepared to detail the substantive argument, the atmosphere in the courtroom had transformed completely. What had begun as a seemingly routine dismissal of a challenging voting rights claim had become something far more nuanced. A serious judicial engagement with legal principles the judge himself had once championed. Legal reporters in the gallery had abandoned their half-written stories about another voting rights defeat. This was evolving into something different. A rare moment when thorough preparation might actually shift the trajectory of constitutional interpretation on one of the nation's most contested legal battlegrounds. Your Honor, Crockett continued, her tone respectful but unwavering. In Little Bear, you established a three-part analytical framework for evaluating Section 2 claims that navigates precisely the concerns you've raised today. Judge Alsup leaned forward slightly, his full judicial attention now engaged. The subtle shift in his posture wasn't lost on veteran court observers. This was the judge's full attention pose, rarely seen unless a legal argument had genuinely captured his intellectual interest. First, Crockett explained, you distinguished between formalistic compliance with voting access and substantive opportunity to participate in the electoral process. Second, you recognized that historical patterns of discrimination create present barriers that may not be immediately apparent from statistical analysis alone. And third, most relevantly to our case, you held that courts must look beyond mechanical application of precedent to consider whether the challenged practice interacts with social and historical conditions to cause an inequality in opportunity. The precision of the quotation demonstrated a level of preparation that transcended typical courtroom advocacy. She wasn't paraphrasing or generalizing. She was citing verbatim from an opinion Alsup himself had crafted, word by careful word, more than a decade earlier. May I approach, Your Honor? Crockett asked, holding a document that was clearly not just the Little Bear opinion but an analysis of it. Judge Alsup nodded, his expression now reflecting genuine judicial engagement rather than dismissive skepticism. As the document was handed to him, several legal observers noted the unusual moment, a federal judge being presented with his own words, carefully analyzed and applied to a new context in ways he might not have anticipated when he wrote them. As you'll see, Your Honor, Crockett continued as Alsup reviewed the document, the brief contains a detailed analysis mapping your Little Bear framework onto the present case. Page 4 begins the specific application, demonstrating how the challenged provisions create precisely the kind of formalistic compliance but substantive barrier that Your Honor identified as contrary to Section 2's purpose. Judge Alsup studied the document with the focused attention that had made him one of the most respected district judges in the country, despite, or perhaps because of, his occasionally sharp demeanor. Whatever his initial skepticism, he was now engaging with the argument on its merits, rather than dismissing it out of hand. Counselor, he finally said. Looking up from the document, Little Bear was decided before Shelby County and Brnovich substantially narrowed the Section 2 framework. How do you reconcile the analytical approach from Little Bear with subsequent Supreme Court jurisprudence? It was precisely the question Crockett had anticipated, the critical legal challenge that would determine whether her strategy of using Alsup's own reasoning would succeed or fail. Her preparation had extended not just to identifying the Little Bear precedent, but to carefully analyzing how it could be harmonized with subsequent developments in voting rights law. That's addressed beginning on page 7, Your Honor, she replied without hesitation. While Shelby County and Brnovich unquestionably narrowed certain aspects of Section 2 analysis, neither case explicitly rejected the substantive versus formalistic distinction that was central to Your Honor's analysis in Little Bear. She turned to a specific page in the brief that had been handed to the judge. In fact, Justice Kagan's dissent in Brnovich cited analytical approaches remarkably similar to Your Honor's Little Bear framework, suggesting that while the majority narrowed the application, the underlying principle remains valid. The courtroom remained silent as Judge Alsup considered this point.
Legal experts present recognized the sophisticated nature of the argument. Crockett wasn't asking Alsup to defy Supreme Court precedent, which would be futile.
Instead, she was identifying the space that remained for principled interpretation, even within the narrower boundaries established by recent cases. Furthermore, Crockett continued, on page 9 we analyze Justice Alito's majority opinion in Branovich and identify 5 specific areas where he emphasized that courts should look beyond mere inconvenience to identify substantial burdens, an approach that aligns with Your Honor's distinction between formalistic compliance and substantive opportunity in Little. Bear, it was masterful legal advocacy, finding the threads of consistency between Alsup's own jurisprudential approach and the Supreme Court's more restrictive recent rulings. Rather than asking him to contradict higher authority, she was showing him how his own reasoning remained valid and applicable even within the narrowed space for voting rights enforcement. Judge Alsup removed his reading glasses, a gesture court veterans recognized as indicating serious engagement with the argument presented. Your analysis is thorough, Congresswoman, he acknowledged, the earlier dismissiveness entirely absent from his tone. But Little Bear involved documented historical discrimination against a specific minority group. The present case involves more general electoral regulations. It was a legitimate judicial concern, and Crockett's response would determine whether her strategy would ultimately succeed. Your Honor, that distinction is precisely why we believe your Little Bear framework is so valuable in the present case, she replied. On page 12, we apply your 3-part test to demonstrate that while the challenged provisions appear facially neutral, they interact with well-documented socioeconomic disparities to create precisely the formalistic, compliance but substantive, barrier that concerned Your Honor in Little Bear. She gestured toward a specific section of the document Alsup was reviewing. The data on pages 14 through 17 shows that while the challenged provisions technically apply to all voters equally, their practical effect is substantially more burdensome on specific communities. Exactly the interaction between seemingly neutral requirements and social conditions that Your Honor identified as potentially violating Section 2. The legal observers in the gallery exchanged glances of professional appreciation. This wasn't just effective advocacy. It was a masterclass in how to respectfully but firmly hold a judge to their own articulated principles across time. Judge Alsup, to his credit, engaged with the argument with the intellectual seriousness that had earned him respect even from attorneys who found his demeanor challenging. He flipped through the document, examining the data and analysis with careful attention. Your Honor, Crockett said, shifting to our most substantive point, what makes your Little Bear framework so valuable is that it acknowledges both the letter and spirit of Section 2. It respects the textual boundaries while recognizing Congress's remedial intent. It provides a principled middle path between the expansive interpretation that recent Supreme Court cases have rejected and the formalistic approach that would render the statute a dead letter. The framing was strategically brilliant, offering Alsup a way to maintain fidelity to his own judicial philosophy while acknowledging the changed landscape of voting rights jurisprudence. Not asking him to defy the Supreme Court, but to apply its precedents in a way consistent with his own carefully developed approach to statutory interpretation. After several moments of consideration, Judge Alsup looked up from the document. The courtroom held its collective breath, awaiting his response. Counselor, he began, his tone now reflective rather than dismissive, you've raised a substantive argument that deserves careful consideration. While I'm not prepared to rule on the merits of your Section 2 claim at this stage, I recognize that the framework from Little Bear may indeed offer a path of analysis that respects both Supreme Court precedent and the statute's purpose. It wasn't a victory. Not yet. But it represented something perhaps even more significant. A federal judge acknowledging that a challenging voting rights claim deserved serious consideration rather than summary dismissal. I'll review the Little Bear decision more thoroughly in light of your brief, Judge Alsup continued. The court will also need supplemental briefing on how this framework applies to the specific provisions challenged in this case. For those who understood the procedural significance, this was extraordinary. Rather than dismissing the case as he had initially seemed inclined to do, Judge Alsup was creating a path for it to proceed, a path built on his own prior jurisprudence, carefully researched and presented by an advocate who had done something rare in federal litigation. She had changed a judge's perspective not through emotional appeals, but through meticulous engagement with his own articulated legal principles. The gallery remained silent, but the atmosphere had transformed completely. What had begun with a judicial smirk and dismissive handwave had evolved into serious engagement with complex questions of voting rights interpretation, all because one advocate had taken the time to research not just the law, but this specific judge's own articulation of it. As Crockett returned to her seat, her expression remained professionally neutral, but legal observers recognized what had just occurred, a moment when preparation and precision had overcome institutional inertia, creating space for genuine consideration of voting rights, claims that might otherwise have been summarily rejected. Before we proceed to the defense's response, Judge Alsup said, adjusting his glasses, I want to acknowledge something important. The courtroom, already attentive after the remarkable exchange, fell into deeper silence. Federal judges rarely departed from procedural formalities to make personal observations mid-hearing. In my years on the bench, Alsup continued, his tone reflective, I have emphasized the importance of intellectual consistency in legal interpretation. Congresswoman Crockett has correctly identified an analytical framework I developed in Little Bear that, upon reflection, remains relevant despite intervening Supreme Court decisions. The statement represented something extraordinary. In federal litigation, a judge explicitly acknowledging the value of being held to his own previously articulated principles. Not a full reversal of his initial skepticism, but a genuine reassessment based on careful presentation of his own judicial reasoning. While I make no ruling on the ultimate merits today, he added, this court has an obligation to apply its interpretive principles consistently across time. The Little Bear framework will indeed inform our analysis of the present Section 2 claims. Legal reporters in the gallery were already frantically typing updates. What had been expected to be a routine dismissal of another challenging voting rights case had transformed into a potentially significant development in Section 2, jurisprudence, all because an advocate had taken the time to research this specific judge's complete judicial record. When the defense attorneys rose to respond, the shift in dynamics was immediately apparent. Rather than confidently arguing for dismissal based on recent restrictive Supreme Court precedents, they now had to engage seriously with Judge Alsup's own analytical framework from Little Bear, a framework that, while respecting textual boundaries, allowed more substantive consideration of barriers to voting rights than more recent formalistic approaches. Your Honor, the lead defense attorney began, his earlier confidence noticeably diminished. While we acknowledge the court's Little Bear decision, we believe the subsequent Supreme Court jurisprudence has effectively superseded that analytical approach. Judge Alsup leaned forward, his expression now reflecting the incisive judicial demeanor for which he was known. Counsel, are you suggesting that this court should abandon its own carefully developed interpretive principles simply because doing so would be convenient for your position in this specific case? The question cut directly to the heart of judicial integrity, whether legal principles should be applied consistently regardless of the specific parties or outcomes involved. The defense attorney's hesitation spoke volumes. Not at all, Your Honor, he finally replied. We're simply suggesting that the Supreme Court's more recent guidance should inform how Little Bear is applied in the present context. That's precisely what Congresswoman Crockett's brief addresses, Alsup responded. The question isn't whether Supreme Court precedent controls. It obviously does. The question is whether the analytical framework I developed in Little Bear can be applied in a manner consistent with that precedent. Based on my initial review, I believe it can, Legal observers exchanged glances of amazement. Judge Alsup, known for his occasionally brusque demeanor and no-nonsense approach, was now effectively defending the analytical framework Crockett had presented against the defense's attempts to minimize its significance. "The court will proceed as follows," Alsup announced, cementing the procedural victory Crockett's strategy had achieved. "First, both parties will submit supplemental briefing addressing the application of the Little Bear framework to this case, with specific attention to how that framework can be harmonized with subsequent Supreme Court decisions. Second, we will hold an evidentiary hearing focused specifically on whether the challenged provisions create a disparity between formal and substantive voting opportunity as articulated in Little Bear. For voting rights advocates who had witnessed a decade of increasingly restrictive judicial interpretations, this represented something remarkable, not a final victory, but an opening where procedural dismissal had seemed inevitable. An opening created not through political pressure or public advocacy, but through one attorney's exceptional preparation and precise presentation of a judge's own jurisprudential history. As the hearing concluded, legal analysts were already describing the exchange as a case study in effective advocacy, not through emotional appeals or broad policy arguments, but through the meticulous research that had identified a judge's own words as the most powerful tool for encouraging him to see a case in a new light. Outside the courthouse, reporters surrounded Crockett, shouting questions about her strategy. Her response would later be used in law school classrooms nationwide. "I simply took Judge Alsup's judicial philosophy seriously enough to believe he would want to apply it consistently. Thorough preparation isn't about winning through rhetorical flourishes. It's about ensuring that legal principles are applied with integrity across time, regardless of which parties appear before the court." The statement perfectly captured what had made the exchange so powerful. This wasn't an attack on judicial authority. It was a demonstration of profound respect for judicial integrity, paired with the expectation that such integrity requires consistency in the application of legal principles. Within hours, the impact had spread far beyond the specific case. Legal organizations issued statements praising the model of principled accountability the exchange represented. Law professors began incorporating the transcript into their advocacy courses, and perhaps most significantly, civil rights attorneys across the country began deep research into the prior opinions of judges before whom they would appear, looking not just for binding precedent, but for the judge's own articulated principles that might create openings for more substantive consideration of rights claims. A prominent legal commentator perhaps best captured the significance. "What we witnessed today wasn't just good lawyering. It was a model for how advocates can hold the judiciary accountable not through attacking its legitimacy, but through taking its principles seriously enough to expect their consistent application across time." Congresswoman Crockett didn't just advance her case. She demonstrated a path for meaningful legal advocacy, even in challenging judicial environments. The ripple effects from the courthouse confrontation spread rapidly through legal and civic circles, transforming from a notable exchange into something more profound. A case study in judicial accountability and the power of thorough preparation. Law schools across the country requested the transcript for inclusion in their advocacy programs. Within 48 hours, 3 prestigious law reviews had commissioned special editions examining the implications of what was already being called the Crockett method, an approach to legal advocacy focused on researching a judge's complete record to identify inconsistencies between previously articulated principles and current positions. The immediate impact on voting rights litigation was significant. Within weeks, civil rights attorneys in 4 other federal districts had adopted similar strategies, researching judges' complete opinion histories to identify analytical frameworks that might create openings for more substantive consideration of Section 2 claims. 2 of these cases resulted in preliminary rulings that allowed voting rights challenges to proceed past motions to dismiss, an increasingly rare outcome in the current judicial environment, but perhaps the most remarkable development came from Judge William Alsup himself. In a speech to the Northern District of California Judicial Conference, without specifically mentioning the case, he addressed the importance of judicial consistency. The strength of our system depends on judges applying legal principles consistently across time, he noted. When an advocate demonstrates that our current approach diverges from principles we ourselves have previously articulated, intellectual honesty requires serious engagement with that inconsistency. The judiciary is strongest not when we never change course, but when we acknowledge the reasoning behind our evolutions. That acknowledgment, from the very judge whose consistency had been challenged, transformed the moment from a courtroom victory into something more lasting. A model for how the legal system can self-correct when principled inconsistency is identified. With precision and respect, legal clinics across the country began implementing what they called judicial archaeology training. Law students to research judges' complete opinion histories to identify principles and frameworks that might create openings for successful advocacy even in challenging areas of law. The American Bar Association developed a continuing legal education program titled Principled Consistency, using judicial history in modern advocacy. Media analysis identified several key elements of what was now commonly called the Crockett method. Thorough research of a judge's complete record, precise citation of the judge's own articulated principles, respectful presentation of inconsistencies, and framing accountability as fidelity to established judicial philosophy rather than as external criticism. The Georgetown Law Journal devoted its entire fall issue to examining the implications, with the lead article titled Preparation as Democratic Accountability: How Thorough Legal Research Serves Judicial Integrity. The article concluded, while our system provides structural checks on judicial power, Crockett demonstrated that the most effective everyday check may be simply taking judges' principles seriously enough to expect their consistent application. Beyond legal circles, the exchange had sparked broader public interest in judicial consistency. Media outlets produced explanatory content helping ordinary citizens understand how judges' prior opinions could be used to hold them accountable for consistent application of legal principles. Civic organizations developed programs teaching community advocates how to research judicial histories relevant to local legal challenges. 6 months after the hearing, its impact was cemented when the full case was decided. Judge Alsup's opinion explicitly applied the Little Bear framework while carefully harmonizing it with subsequent Supreme Court precedent. The result was a nuanced decision that, while not granting all the plaintiffs' requests, recognized substantive barriers to voting rights that more formalistic approaches would have ignored. Fidelity to precedent requires not just following outcomes, but understanding principles. Alsup wrote in the opinion, the analytical framework this court developed in Little Bear remains valid, properly understood, even within the narrowed scope of Section 2, established by recent Supreme Court decisions. When formalistic compliance masks substantive barriers, courts must look beyond mechanical application to fulfill the statute's essential purpose. The opinion was immediately recognized as significant, not necessarily because of its outcome, but because of its methodology. It demonstrated how judges could maintain principled consistency while respecting changed legal landscapes, creating space for meaningful rights enforcement even within narrowed interpretive boundaries. For Jasmine Crockett, the case represented more than a legal victory. It exemplified an approach to advocacy that transcended traditional notions of winning and losing. In a commencement address at Howard University Law School, she reflected on the broader significance. Effective advocacy isn't just about persuading judges to agree with you, she told the graduating class. It's about holding our legal system to its own highest principles across time. When we research thoroughly enough to know not just the law, but how specific judges have articulated and applied it throughout their careers, we create the possibility for principled evolution even in challenging environments. That perspective, focusing on consistency rather than outcome, transformed how many young lawyers approached advocacy in difficult areas of law. Rather than seeing unfavorable judicial trends as impenetrable barriers, they began viewing judges' own articulated principles as potential pathways to more substantive consideration. For ordinary Americans concerned about voting rights and other fundamental issues, the case offered something often missing in legal discourse, evidence that preparation and precision could sometimes overcome even the most entrenched institutional resistance. Not through attacking the system's legitimacy, but through taking its stated principles seriously enough to demand their consistent application. As one civil rights veteran who had witnessed the exchange observed to the Washington Post, what Congresswoman Crockett showed us wasn't just a legal strategy, it was a demonstration that accountability works best when it comes from taking institutions seriously rather than dismissing them. By engaging deeply with Judge Alsup's own reasoning rather than simply criticizing his current position, she created the space for genuine reconsideration in a way external pressure never could have. If you found value in this exploration of how thorough preparation can ensure judicial consistency, please like and subscribe. With your support, we can continue highlighting moments when accountability works through reinforcing institutional integrity rather than undermining it. In a time of increasing skepticism toward legal institutions, the Crockett method reminds us that taking principles seriously enough to expect their consistent application may be our most powerful tool for ensuring that our system remains one of laws rather than convenience.